So again, I suppose it would be either good morning or good afternoon to everyone here. First off, let me introduce to the topic today. We are here to discuss for the next maybe hour or so the topic of written advocacy in mediation. My name is Tat. I am the Weinstein Senior Fellow that's organizing this competition for Singapore. With us, very happy to have Tuan, who is the Senior Fellow who's organizing this competition for Vietnam. And of course, Brinda, who is also here from India, organizing the competition together with Senior Fellow Laila for India. So it's great to see students from everywhere, Singapore, India, Vietnam. And I hope that this might be, right, Tuan and Brenda, the first of many similar collaborations where we get the students together to learn from each other and from the resources and the teachers and professors in all our different countries, right? I think there's a lot for us to share and learn. So the format that we are going to use for how we proceed in the next hour would be informal, right? This is like a fireside chat. We start by first of all having our three very esteemed speakers and panelists. Just want to quickly introduce all of them to you. Professor Dorcas Quack Henderson. She is a professor teaching at the Singapore Management University. Uh, Professor Quack actually is someone that I think all of you would either have known about from previous panels or webinars that you've attended, and you probably would have read her papers on the subject of dispute resolution. Then, of course, we have Professor Mark McCollin, and he's also a professor with the Singapore Management University. He's also a researcher in dispute resolution and legal reasoning, and we're very happy that he's able to join us today as well. Last not least, Professor Alvin Cheng, who is professor with the Singapore University of Social Science. Have I got that right, Alvin?
Yes.
And Alvin, of course, and I were previously colleagues, and he's very much in the mediation space. He mediates as well as teaches. So we're very glad for all three of them, Alvin, Dorcas, and Mark, to join us today. They all bring along with them a wealth of experience, not just in teaching, but in all of them in their respective areas of practice. And Dorcas herself had previously practiced as a judge as well as currently still practicing as a mediator. And I was very happy to have all of you join us. So how we are going to move today in this webinar would be to, first of all, have a little Q&A, a fireside chat among the six of us. I say six of us because apart from Alvin, Dorcas, and Mark, Tuan and Brenda, who are here, will chime in and join us as and when they believe that maybe some of the information or practices that we are talking about might be different in Vietnam and in India, right? So it'd be great to hear from the two of you. But we'll start from that casual conversation, and then at some point, we will move into a discussion about the specifics of the Weinstein International Foundation's International Mediation Writing Competition, which is probably the reason for why many of you might have joined us today. Because apart, of course, from hearing from all the experts here about what mediation advocacy is, and today we are focusing on the mediation written advocacy. You would probably also be interested to understanding and hearing the panelists' views about the criteria for grading the competition papers that we hope many of you would submit in the course of the competition. On that note, maybe let's start the conversation. So um, let's start by exploring, right, the purpose and mindset of parties and lawyers who are involved in mediation, and specifically thinking about written advocacy in mediation. So maybe I would pose the first question to Dorcas and ask, uh, how should written advocacy in mediation differ from what we see in litigation and arbitration, and what kind of mindset shift do you think is needed when moving from adversarial writing to collaborative persuasion?
Yeah, thanks, Tat, for that question. Again, good morning, afternoon to everybody, or evening. I think that chance of that. So that regarding the question as to how advocacy in mediation might differ from advocacy, say, in the litigation context, I think I'll probably emphasize at this preliminary stage two main differences between the mediation process and trial process, which will then influence the way you write or the way you actually be the way the lawyer might act during the mediation. So I think one main difference, which is really the audience in terms of who are you persuading. The second is really the content. What are you persuading them on? Right? What kind of content are you persuading on? So in regard to the first, the audience, right? So if you do write something to say to, and it's given both to the mediator and to the other side, the lawyers and clients, you realize that when you do write to the court, say in submissions, written submissions, your primary audience is the judge. So in a sense, I don't think your primary audience is the opponent, but they would, of course, you need to know how they'll see it. But you are trying to persuade the judge because the judge is the one who will make the decision that will affect your client. So it's directed to that judge. In contrast, in mediation, you're not just persuading the mediator because the mediator has no power to really make a decision that binds everyone, right? But the mediator is there facilitating the discussions and the negotiations. So if you persuade the mediator, that might not really help you because the mediator that cannot really force everybody to then agree with you. So you're persuading not just the mediator, but the other lawyer and the other client. Okay, so compared to judge for litigation, in contrast, it's mediator plus everyone else because they are the ones who have to agree with you at the end of the day. So, and then the second aspect, content. What are you persuading them about? It's a much wider scope of content in mediation compared to pure litigation or adjudication. Because when you persuade the judge, it's purely based on the law, the applicable law, and the facts in this case. So just law and facts. By contrast, for mediation, because the scope of what we discuss is not just limited to the law and the facts, there are many other things that come in, people's perspective, other concerns they have, might be business, emotional concerns. Therefore, the scope is much wider than law and facts alone. So on just those two counts, I think that it will mean your writing is really very different. Once you know your audience is different, you know that the way you write has to target each of their concerns, has to be persuasive to both of them. And then also the kind of content you include is much broader than what a lawyer would typically include in written submissions to a judge. So I'll just briefly state those two differences.
Great. Thanks, Dorcas. So maybe springboarding from that, Alvin, from your perspective, what do you think would one say is the real purpose of a mediation brief, right? Is it about, as what Dorcas has talked about, persuading, informing the other party, clarifying one's own understanding, or is it more about persuading the mediator, or both? What's your view on this?
Thanks, Tat. Short answer is actually both, because what again Dorcas has mentioned, it's about the tone is different in terms of a mediation as opposed to litigation. So the mindset, I think, for litigation is always about who's right, who's wrong. It's a competitive kind of environment. Mediation, the focus is actually more collaborative and problem solving. So quite often the mediation brief is, the tone is not adversarial. So at the end of the day, we're trying to collaborate, we're trying to solve a problem. So the tone and the mindset is very, very different from litigation. So with that in mind, we are trying to persuade the other side to see our point of view and also show or demonstrate that we are here to resolve this amicably. So
Mm.
tone, the way I suppose the choice of words, the language we use is important. It shouldn't be a situation where it's like in a courtroom.
Mm.
So I think that's the first thing, that the tone is important. And for the mediators aspect of it, we also trying to demonstrate to the mediator that we are here to solve the problem together, and also try to get his assistance or her assistance when we are negotiating or mediating the case when we actually meet. So it actually sets the tone for the mediator as well.
Mm.
Quite often the brief, sometimes they come in like in two versions. One is an open one where it's shared with the counterparty or the opposing party. And sometimes we have what we call a kind of confidential brief that we share only with the mediator. And sometimes we can share certain, I suppose, information that is useful for the mediator to understand so that they can help parties move along or during the conversations at the hearing itself. So this is the confidential brief to the mediator. And sometimes that part of it, you can share certain things, for example, your bottom line, what your real motivation and your limitations are. And perhaps the mediator, again, with that in mind, can help resolve the issues when the parties meet. Right? And depending on the conversation, how it goes, because it's very dynamic. Yeah.
Mm. Mm. Thanks, Alvin. On to Mark. Alvin speaks a bit about the need for a persuasive tone in the mediation written brief. Do you think there's a tension between, the brief, a mediation case statement or memorandum putting forward what you might say are facts which clarifies your own position, so the clarifying part of a mediation memorandum versus using that to persuade, or would both objectives fall within part and parcel of the mediation brief? I mean, what would make a mediation brief compelling in that sense? Do you weigh clarification more important than persuasion, or do you think they are both equally important? Sure.
Yeah. Mm.
Great, thank you. Yes, I think for keeping in mind what both of the previous panelists have said, this non-adversarial element, while still being persuasive, is a fine line to walk, but this is really where you can really demonstrate your ability as, your real ability as an advocate. So using, for example, collaborative language. And it's, in some ways, you need to unlearn some of the legal training that you do for arbitration or for litigation, where you are kind of taught to take a position and argue from that position. And it's about really how you're presenting that information in a way that is more broadly acceptable to the other side. So, for example, you might acknowledge the legitimate interests that the other party might have in a dispute. Now, in an arbitration or in a litigation, that's just not relevant information. In fact, it can occasionally undermine your case depending on how strong you think that information is. But in a mediation, being seen to be reasonable both to the other side and to the mediator can really be an effective mode of advocacy, bearing in mind what Dorcas said in that your audience is not the third party necessarily, or certainly not just the third party. And the reason for that, and kind of honing in on the reason for that, I think is important, because even if you manage to persuade the mediator that you are right, so, for example, that a contract is formed or a contract has not been breached or whatever it is, that doesn't help you. It's of no help to you to actually resolve the dispute if you manage to persuade the mediator that you are right. And so I think framing the information that you have in a way that is collaborative, acknowledging their legitimate interest, presenting facts in as neutral a manner as possible. It doesn't mean you're not advocating for the facts as you understand them. But for example, not using overzealous language, using words like our and we, and presenting disagreements as, for example, a mismatch of expectations or misunderstandings. These are all techniques I think that can be quite effective in undertaking that task that you just laid out there, Tad. So I think overall, just one final point would be to present the facts as they exist in a kind of compelling narrative. It doesn't necessarily need to be anchored around these legal issues that we would necessarily have in the arbitration. You don't want to get there. The law's not irrelevant, but it shouldn't take center stage in making your argument, again, because even if you manage to persuade the mediator, or in fact, even the other side that you're right, it doesn't necessarily lead to a settlement in all cases.
Great. Thanks, Mark. So Mark speaks about, the mediation brief. One should present it so that it's seen to be reasonable on your part, not using overzealous language. Segue to you, Dorcas. If one puts that into the mix and use the suggestion by Mark, making sure that your brief is seen to be reasonable and you don't use overzealous language, should then the mediation brief look more like a conversation than a submission? And where do you draw the line between, just writing something that feels more like me telling you as a conversational piece, as opposed to, commercial mediations where it functions under the shadow of ongoing litigation or arbitration, where there's certain formalities inherent in the way that maybe lawyers are asked to write those memoranda.
Yeah, so so you're focusing on how does it translate into in terms of format, style also, right? If you do want to persuade in mediation, is it like are you also asking whether we still cover the law as part of the
Yeah,
format?
do we cover the law and perhaps also in terms of, in the way that one presents it, right? How do you read tone? Maybe it's the other way to ask this question, right? We can hear tone, and when there's the oral advocacy, all of those are very visceral to all of us. But then you take a piece of submission or paper or mediation case statement. How do you then couch it in a way where the reader senses that emotions coming through the paper itself?
Yeah, so actually that is quite a difficult challenge, right? So I would say that there are things you're trying to balance here, in the sense that as both Alvin and Mark have pointed out, you do want to show that you are coming in to solve the problem, right? Rather than coming in to just fight and then just and stick to my position. On the other hand, you don't want to come in to give that impression that you can just walk all over me and whatever you want, I will just give in to you. And if as you're writing as a lawyer representing your client, you do have a duty to prudently protect your client as well in the negotiation process that takes place in mediation. So I think in light of those two things that we're trying to balance, we want to pursue and come across as problem solving. At the same time, you also want to protect your client, which means that if you have certain arguments about how the law should be interpreted, it's not that you don't talk about it at all. You still want it to come across. So in that sense, you don't avoid the law and just make it like a conversational piece, like I'm writing a letter to a pen pal or something, right? So in terms of tone, that there still is some element of formality. Maybe how I could phrase it is that, but it's not as in terms of formal as perhaps litigation, right? But we don't want to swing the other extreme where everything becomes informal and like colloquial and too casual in that sense. So I can give maybe I'll give an example which might make this a little concrete. So you're trying to balance, like I want to come across as problem solving, but I also want to prudently protect my client within the negotiation process. There are some things you might want to still keep confidential, perhaps in the open mediation statement or mediation memorandum that both the mediator and the other side sees. Yeah, because some things in terms of like Alvin alluded to, you don't put your bottom line there, right? That really like doesn't give you much to room to work for the mediation itself. And you would also still want to say, for instance, you still want to not water down when you talk about the law. You don't water down maybe the merits of your case, because sometimes uh, whether you have a good position in law actually does play a part also in the overall negotiation in terms of your bargaining power, right? So you still talk about the law, you might still talk about the evidence that is in favor of your client's position or a client's arguments. While you also talk about, but you can be also neutral and talk about those things that are maybe disputed. Yeah, so this counts towards I'm persuading the other side, so not just a mediator. I'm persuading the other side that I have a good case. It's not like I would definitely be be defeated at trial. And that sometimes might actually still persuade the other side, because if everyone knows it's not the best course of action to go for trial because it's not so straightforward, that might influence or motivate people to negotiate something that works. Yeah, so law comes to the picture, and arguing about the law and merits in a way that's maybe more factual, not like aggressive language or no personal attacks. Then at the same time, you don't stop just at the law, right? As I think my co-panelist has said, you might talk about other issues which maybe is quite plain. My client here wants to have a clean break from this employment relationship. So it can be very public information. You want to put it there. So it's not just a law, but other things that you want the other side to know that my client wants to achieve through this settlement. Yeah. So I think in terms of tone, just to summarize, we don't want to go there extreme to casual. Tone in terms of what info you include as well as the way you write. It needs to balance both the goal of trying to persuade both sides and the goal of prudently protecting your client in terms of advancing the negotiation process in favor of your client.
Thanks, Dorcas. Alvin, to you, the sometimes difficult point about how much to place in the mediation case statement, right, or the mediation memorandum. Um, Question between the tension between strategy, your mediation strategy, and being candid. Uh, how much should a lawyer or a mediation representative highlight, and this is a question that someone has raised as well, the weaknesses and strengths of your client's case without compromising his mediation strategy?
Ooh, okay. Quite quite a few points. I think the first thing is what Dorcas has already mentioned. There's a duty to the client to protect their interest, to advance the client's case, right? We don't be a pushover. Candor is important because it builds trust. And if in a situation we're trying to negotiate, we're trying to collaborate, we're trying to solve the problem, some form of trust is important in terms of the parties. So some candor is important to build that trust, but also there is also a strategy that's required to protect your client's interest and to keep certain things close to your chest, right? But having said that, the starting point has to be, I suppose maybe it's the tone, which we've been saying quite a bit, how we approach it. If we can, for example, volunteer information, certain things that we feel that is useful for both sides to know, we should volunteer the information, that the candor should come out, right? And pick those that will work or will help parties understand the challenges. So sometimes in terms of, rather than state what your weaknesses are, you can always state it as challenges, the difficulties my clients have. Right? If you see it as a problem, as a difficulty, rather than a weakness, it may change the conversation, the direction of how things develop from there. One example you can try in terms of highlighting, I suppose, weaknesses.
So maybe I will segue to Mark and just think about the follow-up question which a student has raised in the chat, right? How should we structure the mediation brief in respect of all the information that needs to be included? What should it look like, in flowing from start to the end? And maybe after you've given your view on this, Mark, I will turn to Tuan and Brenda to see whether you have any views on whether the practices that have been discussed so far might differ in Vietnam or in India? So Mark, over to you first.
Yes, thanks. I think in terms of the order, I think it's quite useful, and I would be curious about the other panel's position on this, to start with your common interests or start with your common positions. Things that come out from the facts of the case that are clearly accepted by both sides and demonstrate that there are clear common interests between both of the parties. I think acknowledging that, and certainly from a mediator perspective, quite often in practice, mediators, I'm sure Tat will know this, are looking for, do the lawyers actually understand this process? Do they understand it is not an arbitration, that it is a litigation, that they're going to have to acknowledge that there are some common interests here which we are working towards? I think that helps provide kind of a solid foundation for when you might go on to talk about more contentious issues, and you can talk with them with slightly more credibility, because you're more perceived as, yes, when there are common interests, I'm quite prepared to understand what those are. I think as you go on, it's fair to say as some of the issues become more adversarial or perhaps more positional in their nature, that might become kind of more sharp as your mediation opening statement goes on. But I think a useful way to think about dealing with it is framing some of these discussions in terms of information problems. So we don't understand why the other party has taken this position. We would like to understand more about why they did this or why they did that. Because I think from a mediator's perspective, it can also help them to begin to design the process, right? Because what you're communicating through your written opening statement is, we understand that this is a problem, but we're framing it not in terms of this kind of core intractable position where we're completely immovable. We're saying, look, we are in a position of disagreement because we have a mismatch of expectations, right? Because we don't quite understand why they have taken one position over another. And I think when a mediator reads an opening statement like that, they can immediately start to think in their own head about the kind of questions that they would ask during, say, an information and a theme gathering stage, or what would be on your agenda. And I think helping the mediator, and if you keep that in your mind about what would actually be useful for both the mediator and the other party to read, can help you write a better opening statement, right? Because instead of just restating the facts as you understand them, you're kind of reorienting the facts as you have them to be more productive for the mediation process, laying out that you are constructive. And I think that word constructive is going to be important. So whenever you lay out, yes, this is our position on one of these factual questions, you want to surround it, right, with a bunch of a tonally appropriate information, but in the way that you present the particular facts that are under dispute and how you think they might be resolved in the mediation itself. Now, that doesn't mean proposing a bunch of solutions. You probably don't want to go so far in proposing lots and lots of solutions so early. But what you might do is leave the door open for, this is the route that we might go down during the mediation itself, in order for, I need to learn more about this particular contract, or what they think about the market, or what they think is going to go as happen in the future, leaving those doors open, right, for the mediator to then in the process itself to help you walk through. And I think that when you read an opening a kind of written mediation memo, and you can see that those doors have been left open by the advocate, I think is a good way to think about what makes it that kind of writing effective.
Nice. So at this point, maybe let me just spotlight Brenda and Tuan, and ask you to, let me just add you first, and then I'll unmute you, and maybe ask you to just say, from what you've heard so far from Mark, Dorcas, and Alvin. I mean, would there be any of what they say that you think actually would look very different in India or in Vietnam, or any other things that you think would be helpful to the students to add to the discussion? Maybe first Tuan, and then Brenda.
Oh, thank you, Ted. It's a very interesting discussions. And from following Mark's, I've got the points about the skills to unlearn the law, and from Anvin, it's about the the mindset to collaborate. I think it's very important. And from Dorcas, I've understood further about the audience that the writers have to keep in mind in the mediation advocacy. And from there, I think it's pretty well works within a communities. But if we can expand the communities a little bit further and understand in a way that if we are talking about keeping the tones, then the cultures might play in a factor. I mean, in one culture, this tone sounds to be really straightforward. Let's say in the Western side, I mean, using this tone is like candid. But in Asian size, I mean, this tone might sound a little bit too aggressive. So how do we read the tones and use the tone in taking consideration of culture play important role if we're talking about cross borders kind of dispute resolutions in mediation, and even in advocacy, in written advocacy. I mean, one can still structure the tone in a way that take the cultures into consideration. Because I don't know about others, but in Vietnam, we normally talk about faith saving. It's about being politeness, being not straight to the point. It might be disadvantage in consideration of the Western ways, but in Asia, I believe that that could be something that one should keep in mind.
Thank you, Tuan. Very helpful, bringing the cultural element. Brenda, your views?
Thank you, Tat. I think this is a very useful session. I'm sure the students are going to take away a lot of this. So I think our culture is pretty much the same, South Asia, like what all of us have been talking. So I could just connect to all of you. But I'm saying this mediation brief writing is more of a setting the stage for this. I think this is a very important stage when where you have to, when you're putting out the mediation brief, where you're going to be telling the other side what your perspective is. So that is more important here. And to get, because the lawyers will be talking in a adversarial, so the mediator would be removing the adversarial platform and trying to get the lawyers into things. So where the lawyers and the parties, when they're going to be putting out their mediation brief, it's more of their facts and trying to put out their perspective and make it easier, and where it's easier for the mediator to understand where the problem is going or heading. So I think this is where it's pretty much the same culture what the Asia we were all looking at, I think.
Thank you, Brenda. I wonder whether Alvin, Dorcas, Mark, do you have any thoughts in response to what Tuan and Brenda might have said? And if not, we can sort of move on a little bit to talk about ethics, transparency, and strategy. But let me just open the floor and see if anyone has any comments to weigh in at this point.
Maybe just very briefly on the cultural issue. So obviously I'm from a Western country, but I've done lots of my research on particularly Chinese parties' approach to dispute settlement. And what you see in the data and in the literature is that cultural gap is real. It's real, and it's important for practitioners to recognize that they come from a particular cultural background and may or may not be blind to the cultural backgrounds of other places. So the particular context I see it in is investor-state disputes, where you have quite similar levels of investment from particularly American parties and Chinese parties, but the instigation of adversarial processes much higher from American and particularly Western European companies when you look at, for example, Chinese companies. And either it is the case that Chinese companies don't get into disputes, which I think is unlikely, or it is the case that these are being settled in other ways, quietly, in more confidential ways. And so certainly in practice, it's something that students should be aware of, that you come from a particular background and how that relates to your counterparty.
Thanks, Mark. Alvin, you're unmuted. Did you want to add to the conversation?
Yeah, I just wanted to add on to what Brenda mentioned about setting the stage. So the mediation brief is actually the first document which the other side will see probably. So it's important, the first impression is important. And with the culture issues, if it starts on the wrong foot, if the wrong words, the choice of words are used, the tone is difficult, it's going to make it an uphill task for the mediation hearing itself. Yeah. So first impression important. Think hard, long and hard, how you want to express or give what your first impression is going to be like. Yeah.
Dorcas?
Yeah, I thought I'll echo what Alvin said in the sense that the other client, the other side, the client will be reading your mediation statement. So it's a first impression for both the mediator and the other person who sometimes might not understand whatever convention or what normal language you might use and might easily misinterpret. So I think this is where what both Tuan and Brinda said does matter, to bear in mind the other person who is going to read it. And in this regard, of course, cultural issues might come into play. So if, for example, like what Alvin said, the first impression can be really bad. So if someone is not used to very direct language, and then there's another culture that comes into play here, not just the respective clients, but the lawyer culture in a relevant country. So regardless of both sides' culture, sometimes certain lawyers or certain firms might write a certain way, if I could just put it that way.
Yes.
And if there's a certain modus operandi or practice that they just write in a certain way, which does not get adjusted or tailored to the people involved, you can imagine how the mismatch can happen. You can imagine how the misinterpretation might take place. I do recall once when I dealt with one fairly emotional dispute because there were a lot of misunderstandings, and there's a relationship breakdown that contributed to the dispute, right? So, but if the statement itself was written like how some lawyers' correspondence is written, and it really caused the other side to at the get-go of the mediation of the day itself, they were already far apart. They were already alienated just because they read that statement. And if the lawyer doesn't explain to them or just say, no, this is normally how they write, they would think that, what is this? Are you coming to mediation with a sincere, good faith attempt to settle, or are you here to just attack me? So I actually saw that, and then it resulted in my mediation having to start on a very difficult footing right at the beginning. So I do remember the language being used. I'm trying to give you some sample without disclosing too much. But I do remember, for instance, someone said like, this is like a blatant, also it's written out, this blatant attempt to this is it's very blatant, and then it's also making some personal attacks that about bad faith. And so the whole statement was peppered with such kind of language that sounded like very accusatory and attacking. Okay, so then it really caused the other side to take offense. Yeah. So I thought I just quickly address some of the concerns about the common structure. So we are not giving you a standard structure because it might vary from person to person and different dispute to dispute. But I think what would be helpful to realize is that if you just compare it to the normal structure for legal submissions, lawyers might sometimes say what the facts are, right? Then after that, they go to your legal arguments. So those are the typical things. And then legal arguments, you got many issues. So probably you also do want in a mediation statement to also cover things like what summary of the facts, as at least from your client's standpoint. And that's when you craft the narrative, then all these advice that we have been talking about might come in terms of the language and how you craft a story. And also to point out where certain facts are actually disputed in a very neutral way. So that, in a sense, sets a background, right? But then you can also set the background in terms of what the legal issues in dispute. So this is where when we mentioned just now about talking about legal arguments, those are still relevant. So when you talk, you might not want to say, this is my weakness, no, but you might weakness in my argument. But the way you can put it, sometimes you say, these are the issues in dispute. The other side says this is our argument. And then, of course, your argument, you try not to water it down and not be personal or accusatory in language. You can always say which ones are disputed, right? Without really being so over candid to the point of saying I have a very poor case. So then you can also talk about parties' concerns. So this is where like Mark and Alvin talk about interest coming out. So it's not just the law. What the mediator also likes to find out is like negotiation history. Were there prior negotiations? No doubt some of these offers made were of course confidential without prejudice, but because mediation itself is confidential without prejudice, it's helpful for mediator to understand the background of the negotiations. So you know the background. Then some people might want to say, even talk about potential solutions, but being careful, of course, not to just give some ideas. We could explore things like that, okay, rather than giving a very firm offer. Confidentially, sometimes Alvin did allude to this earlier. If confidentially you write the mediation, sometimes you want to tell the mediator what are the obstacles to settlement, which you might know because you have been involved, or what are my views to the mediation as to how you can assist us, right? Or appropriate mediation interventions that will address those things. Yeah. So I just thought I'll list some of those
Very
things
helpful.
that are helpful to include.
Very helpful. Tuan, earlier on, you mentioned you had your hand up. Over to you.
Sure. I just, as we heard from Dorcas and the other panelists, just some memories from the trips to the US brought me back to one of the book written by Janet Martinez, a professor at the Stanford University. And she wrote a book about dispute resolutions or something like dispute system design. And I think what I get from that kind of dispute system design is that do not think only about the two parties disputing with each other. Think about the impact of the dispute could be about the public interests, the media, the industries associations, the investors, community, suppliers, business partners. So when parties have the kind of a dispute and they're considering to mediate that, besides keeping relationship between those, they might also consider about other stakeholders. They might have some influence behind the back. We never know. If we could somehow take care of that part, I think it could also help the mediation advocacy in certain ways that we never know. Just my idea to chip in.
Is a great contribution. Well, what I think we want to do now is to look at quickly where the mediation memoranda or the case statement or the position paper. There are different ways to call these papers that are exchanged before the plenary session or before the mediation actually starts proper. And then look at the criteria for the mediation writing competition. There are 9 criterion. What I'm going to do is to use the slides just to walk quickly through the 9 without talking about each of them. And after that, I will then invite everyone here, the panelists, to maybe give their thoughts on the 9 criterion and what to them might be things that the students need to take away if they are going to participate in the student competition. But let me start by just quickly walking my way through this slide, which is first of all important to set the stage that where we are asking you to prepare the mediation memorandum. The memo itself is intended to be exchanged before the start of the mediation. So it happens before one might call the single day mediation, or one might call the plenary session of the mediation where people come together and begin the mediation proper. Of course, in many commercial mediations, people do actually have pre-mediation meetings. The mediator chairs those meetings, and sometimes those meetings are just with the lawyers. Sometimes they are together with all parties and the lawyers. Sometimes they are with each party separately. It is entirely up to the parties' decision to be made in conjunction with what the mediator guides and suggests. But this particular memorandum that we are inviting you students to participate and present and submit for the competition would be a document that's exchanged, you writing as a lawyer on behalf of your clients and exchanging it with the other side before the plenary session or before the mediation proper actually begins. Which actually brings us then to, of course, the question about these criterion, right? There are 9 criteria altogether. And I'll quickly run through the 9. I'll stop share, and then the panelists will discuss what is the expectation of this competition when you're looking at each of the 9 criterion. So first criterion is to summarize the facts effectively accurately, and completely. Now, you will find this 9 criteria in the competition packet, and in the competition packet from page 6 onwards, page 6 to page 8, you will see each of these 9 criteria with a description of what they are required, what entails for each of the 9. So this is the first. Second is to use law appropriately. Earlier on, Mark mentioned that you don't leave law outside of your consideration in writing a memo, but in your memo, you can use law, and certainly there's no reason why you would not use law, but use it appropriately. And what does that mean? We'll ask the panel to unpack that. The third criterion is obviously something that Alvin has spoken about, Dorcas has spoken about. The object of the memo is persuade the other side about the strength of your client's claims. And also, criterion 4, to invite the other party with that in mind to negotiate in good faith. And within the memo, it's useful to provide the mediator with a description of what were the history of negotiations which parties have entered into prior to coming to mediation. And then in criterion 6, listing out the obstacles, realistic assessment of what the obstacles are to the settlement so that the mediator is informed. And whether this should be in a open statement or in a private statement to the mediator, that's something we can talk about very quickly later on. Criterion 7 is to provide within your mediation memo useful and workable strategies so that the mediator is guided in determining what the appropriate approach should be for the mediation. In criterion 8 is that you might then within your submission consider a private confidential information that you might only share with the mediator and not with the other side. So there would be within your submission an open part of your submission which is shared with the other side and the mediator, of course, and a closed confidential part that is not shared with the other side but shared only with the mediator. And of course, finally, the idea of putting the whole package together so that the mediator, when they look at this statement and for the competition, when the judges read your memo, it reads like a well-written, excellent memo, which should be well worthy of winning a prize, one of the many prizes that you will have, whether you are participating in the India competition or in Vietnam competition or the Singapore competition, right? So that's what we would like you all students to bear in mind when you're participating in the competition. So back to all the panelists again, and thinking about the 9 criterion, maybe let's start with the first, and with no particular order. On my screen, we're just going to do a round robin, right? I will start with Alvin, then on my screen is Dorcas next, then Mark, Brenda, Tuan, and let's walk our way through the 9. And as one of you puts your perspective on what that means, the others can chime in if you have a different view or we want to augment. So Alvin, first to you. Criterion 1, right? An excellent memo summarizes facts effectively, accurately, and completely.
Oh, okay. Facts. Yes, I'm probably thinking like I suppose as a lecturer when I'm setting assessment, the problem is word count. So the facts important to be as concise as you can, the more relevant facts that will help in the dispute. So there's no point repeating too much facts that are not so relevant, or at least you try to summarize it such that you don't waste your word count. So I think that's one of the first thing I would consider, the word count. Time may be better spent on finding, identifying issues and trying to clarify certain things. So facts, yeah. So that's what I'm thinking.
Okay. I'm just looking around. Any violent objections to what Alvin has said or any other thoughts? If not, then criterion 2, Dorcas, excellent memo uses law appropriately.
Yeah, so I mean, here, I think we might defer the question about applicable law to later, right, Tat?
Yes.
Yeah, but so in general, I'll talk about using the law appropriately. So you notice in the package, it says the most effective memos are much lighter on the law than the memos written for a judge or magistrate called upon to render a decision. And the memo should alert the mediator to any relevant rules that mediators should be aware of, but stops short of being a legalistic argument. Yeah, so I think here it's actually like quite a few things to balance, right? So just to clarify, when you say lighter on the law, I think so probably following from when you have already narrated the facts, then of course you might want to say what is the argument that I will be likely to make based on the law. And that this flows in very well to later the criterion 3 about being persuasive. But it's just you probably need to identify at the very least what principles of law are relevant here. And so because then the meter has to be aware of it with the relevant sources and probably with some kind of indication what your argument would be, right? But maybe not like so comprehensive as what you would say in the court, like according to this evidence, according to the evidence. And in this respect, sometimes not just the law that you talk about, it might be useful sometimes the information. So the information or the documents that relate to the so-called facts, because some of these things might have to be disclosed on a without prejudice basis. I'll give you an example. Sometimes you say like, I have this loss, I suffered bills, medical claims, and then you don't put any documents to substantiate those claims, and the other side has not seen any of these before. So you can imagine it's very difficult for someone to accept, right? So some certain things, documents might have to be disclosed on a without prejudice basis to substantiate your case a little better. In this regard, if you look at, I would just like to point out that if you look at the state courts practice direction, the state courts of Singapore, and look at Form 9J in particular. So I should stress that this is by no means a template, but it was one template that was suggested by the courts when parties attend mediation that is conducted by the courts. So it is rather heavy on the law. That is what I should say up front. This template is heavy on the law, but the reason is because parties have already filed a case in court. So they already have all the documents there. Okay, so that's the context. So if you don't have a case in court, then probably you won't be as heavy on the law. But I think it's helpful to look at Form 9J because they do set out what are the issues in dispute. You can state it. They do also say if you have certain evidence, be it you're going to rely on witness or some documents, to also list it and give the other side awareness as well as the mediator awareness. Yeah.
Great. Yeah, I see Tuan has disappeared. I'm going to add him back to the spotlight. But next, actually, before leaving that topic, Dorcas, there were some questions raised by the Singaporean students about the applicable law, right? So we know that in the write-up for Criterion 2, it says the simulation contains no applicable law. The applicable law is the law that students are taught at their law school. So in this regard, I think the answer to students asking, when we look at the problem and consider what the applicable law might look like, for the Singaporean students, I think you'll be saying to you, consider that the governing law would be Singapore law. And for students coming from Vietnam, the governing law would be the law of Vietnam, and likewise in India, governing law would be the law of India. I think we're probably all aligned on that front. Yeah. So over to you, Mark. Third criterion. Excellent memo persuades the other side about the strength of your author's skills. And it's something you spoke about already earlier.
Yes, and I think the overriding theme that you'd be looking for in this section is to persuade both the mediator and the other side of the reasonableness of your position, that you're reasonable, you're being fair, and not overly relying on, for example, very technical legal arguments, because they can sometimes undermine these appeals to fairness. A couple of things you almost want to avoid, and I think in this section it's quite useful to have a kind of do not do list. So things like avoid blaming the other side overtly. These are some things that Dorcas mentioned in her reading out her email, and saying things like the other side refuses to do this or they demand this. You say that the parties have not yet agreed or the parties recall events differently. You don't say their version is false or they've violated the contract. You say there's a disagreement as to whether this provision has been met, or using language that just makes you sound more reasonable, less assertive, and more to do with the art of persuasion rather than the art of taking a position and arguing strongly from that position. It's why I said earlier that you slightly have to unlearn some of your legal training. I think that's probably not quite right. I think you need to be very aware of how you're legally trained, but just reorienting it slightly. How can I do this in a way that's more effective, bearing in mind my new audience, right? Think about when someone's trying to persuade you of something, if they're taking that, very strong position and arguing from it. I think people are in general less persuasive when they don't, for example, acknowledge that the other side may have some points to make, right? That the other side may have interests that have gone unacknowledged in the dispute so far. And remember, the reason why these are useful for a mediation is because of the confidential nature of mediation. They can't then be used in a future adversarial proceeding. And so you can admit, I think admitting liability can go too far, I think, in some cases, but certainly acknowledging that there has been some fault on one side, or there has been some mismatch of expectations or miscommunication. These are things that can help boost your credibility to help make your claims more persuasive. A couple of other things just before I conclude on that. Firstly, instead of providing for excuses for things that you've done, you're looking to provide more, looking to provide context, right? So always providing more additional information. I think I would replicate what Alvin said, is that you don't want to be simply repeating the facts and taking up words that you need. But I think if you can contextualize some of the facts that you have to tell in a manner that is partial. So you're a party to this dispute, but also not necessarily too argumentative and not kind of too entrenched in your position. And I think if you manage to do all of those things, walking that fine line between, on the one hand, it's a non-adversarial process, and on the other hand, you are partial to one of the parties, that's really the key line to be walked here, I think.
Great. Mark, and so next criteria, an excellent memo invites the other party to negotiate in good faith. I actually can't remember whether I said Brenda first or Tuan first, but either of you. Brenda then.
Yeah, I can go. So the negotiation part, when it says, so I think the part where you have to keep in mind what has already been tried, you try and avoid that and try using some other kind of negotiation tactics, because what has failed, you don't go back and try again. Those facts, like they mentioned, those facts which didn't work out, that's why you come in here for mediation and try doing it another way, where the mediator will also help that kind of negotiation to happen in the future. So I think to keep those points, because negotiation, that is another language for brief writing, where you go to negotiate with the other side what you really want. So keep in mind, don't use those facts which is already used. Use something else which is not used. Maybe there could be those options. Open out, keep it open, as they can be trying out those, and maybe the other party has not seen this, and go forward with that. So that's what I would like to.
Thank you, Brenda. Tuan, next one, criterion 5. Excellent memo offers a helpful description of the negotiation history.
Well, I think it is clearly said there that you do not want to make the same mistakes. If the previous if the previous ideas doesn't work, then do not try to do the same thing. It might be just a waste of time. I think the idea about bringing up the what is that here? The negotiation history is just to emphasize one of the key things that I think it's going to make sense is creativity. So if you already know about what has not solved in the past, then maybe you have to bring in something new to the table. I always tell the students that bring in something that you can exchange. I mean, do not come in and say, I don't know, or we have nothing to exchange here. So, I mean, mediation is all about understanding the interests of the other parties. You have to take care of their interests. And therefore, if the creativity could help bring in something new, I mean, that is something that we really need to stress it out. And using the history is just to show that, well, that doesn't help. Now here's a new thing, kind of differentiate what didn't work with the thing that could possibly work. But look, Ted, I want to share a little bit feeling here. I feel like a little bit like I'm in a competition where I need to really have to show that I meet all the factors, like nine, whatever factor. It really difficult, even including myself when meeting those kind of thing. And I think students the same. So I always tell my student that it's the learning journey, including myself. But one of the way that student might skip that by just putting everything in AI. I know you're gonna touch on that point, but I include that everything in the answers. You know, that might be one of the things that I don't know if other people might have different opinions in that. But I look forward to the next discussion on that.
Right. Yeah. Yeah, and I like the part where you say at the end, this is a learning journey, right? So while we are touching on the criterion and the 9 criteria for students who are tuning in and maybe listening to this in the recorded version later on, use this opportunity to learn, right? And it's while it's nice always to participate in competition and to come up with a prize or two, the key really is to use the opportunity to learn as much as you can because you know the prize of every professional is to be a great professional in whatever field you decide to pursue in the course of your journey as a professional. Okay, just 4 more to go, or rather 6, 7, 8, 9. Yeah, 4 more to go. Let me just quickly deal with 6 and then we'll circle our way back, right? The criterion 6 is an excellent memo, offers a realistic assessment of the obstacles to settlement. To me, the words that stand out to me is realistic assessment of the obstacles to a settlement. And so often, I think in the work that I do, both as a mediator as well as a counsel, right, a lawyer acting for a party, you often find that lawyers are usually very sensitive about putting realistic assessment in the mediation case statements that often lawyers write for the client. You diminish the obstacles insofar as it's your obstacle, your side, and you enhance or inflate the obstacles you think are on the other side. So that might take the form of us looking at a case and saying that we think that we stand a better chance of prevailing in court or in arbitration compared to the other side. And then you have a skewed reading in the application of the law and skewed reading and interpretation of the facts. So I think that sometimes may actually impede rather than help your parties, your clients in the mediation process, because the other side, when they read your statement, they will get the sense that you're not being fair-minded, you're not being measured, you're not trying to do problem solving, joint problem solving, but trying to posture, trying to impose a view which they don't share. And so this criterion 6 often is one where if it's correctly, delicately done in the right way, where it resonates with the reader on the other side, and especially if it resonates also with the mediator, you will come across as someone who they can do business with, that they can participate in the process to do joint problem solving with you. So being realistic in your assessment, and you feel sensitive that you cannot be too open about the realistic assessment, well then, you could then park that in a private confidential statement to the mediator for his eyes or her eyes only, right? And that's something that is worth thinking about. Okay, that's criterion 6. Criterion 7, I'll go back to Mark and then Alvin and then finally work our way to Dorcas again. 7, an excellent memo proposes useful and workable strategies to help guide the mediator in determining his or her approach. Mark.
Yeah, I think what will be useful for you to bear in mind when you're drawing up your mediation memos for this bit of the criteria is to have a very good understanding of what the role of the mediator is. I was going to say what the powers of the mediator is, but that's going slightly too strongly. So what their role is in designing the process, right? Because how you're going to address your comments to the mediator should directly be impacted by your understanding of how they can actually affect the process, right? You're not just giving them random information, you're giving them information with a specific outcome in mind, or at least a series of outcomes that might happen when you communicate that to the mediator. So, for example, the mediator is going to have a significant role in potentially establishing the agenda for a mediation. Now, what you don't want to do is propose agenda items, right? But what you might want to do instead is to direct them to the most important elements of the dispute potentially for your client. Most likely, you would have that potentially in the confidential section, but bearing in mind that the mediator influences the process at these. There are what I would say critical stages of the mediation process. The agenda setting, I think, is one of them. How the agreement and how the discussion then proceeds is another one. For example, the kind of issues that we might deal with first. These are relevant issues that you might want to suggest to the mediator to say, look, we would be happy to discuss these other secondary issues, but what's really important to us is we resolve this one first. We think these second ones, if they can be resolved, they will be resolved if this first one is resolved. For a mediator, that's really important information, right? To be able to understand that you've organized this information in a way that makes sense, that is geared towards a potential settlement, bearing in mind that the mediator cannot impose a settlement on the parties, but they can design a process in such a way that the negotiation is facilitated in the most constructive manner. So agenda is one of those. Potential for a private caucus is a second one. So if you would have information that you may not want to disclose, up front, and I think a subsequent criteria, I may be stepping on the toes of that one, about what you're going to disclose in your confidential information versus the public information. The reason why you might hold back information and explaining why you're holding that back can help demonstrate, certainly to us as judges, and when you're in practice, what makes a good statement is that you understand what the role of the mediator is. Right? If you're saying to the mediator, I want you to do this and I want you to do that, they're just likely not to listen to you. But if you are to propose to them, look, this is useful bits of information at this stage, we think, in the dispute. These are how we think these issues link together. These are most important for us. We think this is most important for them. And if, for example, giving a good understanding or a reasonable summary of what you think the other party's position is can also be useful, because then the mediator will be in a position of seeing both of sets of confidential information. And if there is a mismatch in that, the mediator would be able to draw that out in a way that's kind of organic in the mediation itself. So I think getting parties to a position where they have the right amount of productive information about one another, removing these misunderstandings where they exist, I think is an important way to think about how you might structure using the information you have to guide the mediator and how they're going to design the process.
Thank you, Mark. So important, because sometimes parties and lawyers think that you go into a mediation process and you go on autopilot, let the mediator do what the mediator thinks is most appropriate. But focusing on guiding the mediator, using the mediator appropriately is one of those things that students, when you participate in competitions, that point is often reinforced, right? And that's one of the criteria. Alvin, over to you. Criterion 8, I think, is a topic that we sort of briefly touched on. Excellent memo effectively breaks down the info between the open to be shared with the other side, part of the memo, and the closed, which is confidential part.
Yes, I think there's quite a lot of overlap between the strategy and the earlier criteria and the information exchange. So quite often to solve a problem, we need intel, we need information. So we need to decide in terms of what information we are willing to share and what we want to keep close to our chest, right? So those we want to keep close to our chest, we don't reveal so early, we want to put it in the confidential statement. Whereas something you want to share, something that you're happy to share because it may be constructive, it may help the party see the difficulties or challenges that your clients have. So the information in the open should also give the other side an insight of what challenges that your clients may be facing and how, I suppose, the other side can help resolve it. Because the mindset for mediation, it's a collaboration because we're trying to help solve each other's problems. So if I scratch your back or you scratch my back, there's a reciprocation involved. So if you can share some information that will be helpful, that perhaps the other side can see and they can help you resolve. Likewise, you can also in your statement offer to resolve any difficulties the other side may have. Right? I suppose in the competition, this competition, I don't think you have both sides of the statements. You haven't seen the other side statement, so it's kind of one-sided. But in the real mediation, when you read the opponents or the counterparty's statement, you will also have an idea what challenges they face, and you will also think about trying to help them solve their problem. Because if it's something that your client can solve towards an agreement at the end, because if you scratch my back, I scratch yours, and then we can get an agreement. So sometimes it's good to offer your, I won't say your weaknesses, but sometimes the challenges that you face or your client faces, so that the other party can help.
Thank you, Alvin. Last but not least, the criterion 9, which is just as important in real life as it is, and maybe even more important for the purpose of the competition. Dorcas.
Yeah, I was looking at criterion 9 and it starts with this sentence. This point ought to be obvious. So it says excellent memo is well written. Right. Yeah, so I teach legal research and writing, for almost 10 years. I've taught it for almost 10 years. So I just probably can't overemphasize enough that some of these sometimes overlooked matters, like say how we write, can actually ruin the whole impression of that person when the mediator reads it or the other side reads it. So I mean, although it's obvious, maybe some things might be helpful to note in this regard. One is probably this also applies to legal writing, and those who have done the course will be familiar, or those who have done quite long ago, maybe it's good to have a refresher and to look at books, for example, like elements of elements of writing and all those legal writing books. So I mean, just in general, just it's better sometimes a simple sentence structure, not too convoluted things that would sometimes make it difficult. Not too many direct quotations that make it difficult to read. So putting the subject, verb, object close together rather than having many clauses in between. Being even strategic when you have short sentences so that you make an impact, and then after that you vary it with perhaps a longer sentence. Being strategic as to what you put in the first part of your sentence so that you draw attention to the main idea of your sentence rather than put it at the back. So some of the things is actually something is good to be aware of, and always for writing, I think it's important to just bear in mind your audience. Right, so the audience is if it's a mediator, also as you mentioned, tone is still fairly formal. So you don't write like, hey you guys, what do you think about this? No. So not that kind of casual tone. Perhaps maybe also think about, I think Mark alluded to this, even the words that you use that could actually suggest is a joint collaborative problem-solving approach. Right? Rather than usual in your adversarial process, my client, and then my learned friend or the opponent, the defendant, at least give them a name, right? Sometimes just giving people a name makes it more personable. It's not like some hidden, demonized, villainized person who is unknown and just characterized according to a term, the defendant, right? Or like learned friend or being sarcastic to your side, probably that doesn't really help. Even using words, I think Mark mentioned like we, right? So we, although it just sounds like a simple change between we and then I versus you or we versus them, but if everyone is collectively part of that we and say we have tried this solution, it didn't work, it has an effect. And bear in mind this relates to the audience. The other audience is the other side. So if you convey that no, we are working together on a solution, it makes a great difference. So words actually have such great effect, which we don't realize sometimes.
Thank you, Doctor. So that concludes the 9 criteria. And, I hope students who are here today will get a heads up on what is expected of you in the competition. And, those of you who have been here and you've listened to what those 9 criteria should look like in your submission, I hope you sort of bear in mind what the panelists have all said. when you are presenting or crafting your submission. Now, there are just a couple of minutes more for the questions that we have. I can see three questions in the chat. The first is, and to anyone in the panel who, feels that strongly about an answer to these three questions. First of all, from Yachna Nimi, the law is used for differentiating what is wrong and what is right. How can the law be used to set the middle ground in disputes?
I could address that. So this will, yeah, is it okay?
Yeah, of course.
Yeah, so this relates to also knowing what's the role of law in negotiation, because mediation is facilitated negotiation, right? So try to understand what role does the law play. So for those of us who know this terminology in negotiation theory called alternative, and specifically BATNA, the best alternative to negotiated agreement. So if you have a good case, that means you are strong in your legal claim, you go to court. That affects your what we call bargaining power in a negotiation. So put it very simply, if I go to court, I know based on evidence, I will surely lose, right? More than 80% chance of losing. What would that mean? It would mean that in this mediation negotiation, I really have to make it work. Or maybe it affects my range of options, because anyway I go to court, I won't get more than X dollars. So why be so inflexible about my range of options? So a law relates to this, what we call the alternative. What will happen if we don't reach an agreement at the mediation? And it's helpful. It helps each side to have a accurate understanding of that. Many times, almost every mediation I've encountered, the lawyer comes in their first mediation statement, they say, okay, this is our position. Then after they see the other side's mediation statement, after they've undergone the mediation, their view of their chances of success changes. Sometimes it changes dramatically because some things are revealed which they never knew. Their client didn't tell them. Okay, so now then they say, oh, maybe it's not so straightforward. I might not win. Okay, and then that will then affect how they negotiate already. Sometimes it's not so straightforward who will win. It also helps because we know that it's all disputed. You go to court, you may win, I may win. It's like 50% chance of each winning. Why take our chances in court? It's still a not very good alternative if it's not so clear cut. So sometimes if it's disputed, the law is disputed, actually helps in negotiation because we realize, let's make this work. We are more motivated to make our mediation work. Okay, so it doesn't really shift you to a middle ground in that sense, but sometimes it's helped to convince the other side or offer more information so that they have more realistic view of what will happen or about their partner. Yeah.
Thank you, Dorcas. Next question relates to what the structure of the mediation memo will look like. I'm going to ask Mark to answer that, and then to Brinda and to Tuan from the India and the Vietnamese perspective. Mark, because Mark has been a judge in this competition in the last year, so maybe speaking about this question, could the panelists give guidance as to what the structure of the mediation memo should look like? What are the appropriate sections to have, which sections go into open part and which to the closed part? Mark, over to you first.
All right, yes, I think there are three ways that I have seen students approach it. I think that's the best way to answer this. The first is people who write their mediation memo completely in prose. So from the beginning, it's essentially just like a submission to a court. So the paragraphs are numbered, for example, but they don't necessarily have headings splitting up different parts of the memo. The second way that a mediation memo might be structured would be what I would describe as kind of pro forma titles. So you would have things like, introduction, background issues, issues to be discussed. And that's the second way one might do it. And a third way one might do it is to organize titles yourself based upon the information that you have. Now, I don't think one of these is necessarily better than the other. I think sometimes that third one, where you choose your own titles and are framing the information, is I think what a most effective way to write a very good one, but it's also the most difficult way to do it, I think, because it requires a lot of your judgment in determining what issues are important and in what order you should put them in. So I think for potential, I think either kind of the prose version or doing your own titles version is the best one, purely because it involves more of your own judgment. So when we are judging what are the better mediation memos, we can say, well, they have made this decision, and I think this decision is well supported by the facts here or here or here. And so while it might be tempting to, so for example, to go online and look for mediation memos that have this kind of pro forma structure where they give you the structure, I think it will be tempting for you to do that. I would probably advise you not to do that and see how much of your own judgment you can use. This is a forum in which you have nothing to lose, right? This is not a real case. And so if you end up on the other side of this with a very excellent memo, maybe in the top 3, you can demonstrate that your judgment has been good. So those are the 3 ways that you might do it: completely prose, those pro forma titles, and doing kind of titles of your own. But I think certainly the first and the third give you more opportunity to express how you have made and how you have engaged in your own decision making over those facts.
Thanks, Mark. Brenda?
Yeah, so I think when we would be giving the guidelines to form your mediation brief, so 2 points which we'll be looking at: an open and a closed one. Open one would take more of what your perspective is, what is your problem, you're looking at your interest, you're going to putting that out so that the other party sees this or the mediator sees this. What I would be putting in, I mean, I would suggest we would be looking at in the closed, be more of something which is very emotional, which maybe would connect to the mediator, seeing that this could be helpful for the mediator to know what kind of emotions were involved in this process, which would help her or him to go forward with. So that's what I look at in a mediation.
Thank you, Brenda. Tuan?
Well, I look at the list of questions. I don't know what to start with,
Oh,
but
no, it is a question that on the what the structure of the mediation memo would look like, which are the appropriate sections to have, which sections go to open and the closed part, trying to understand that, Mark is speaking about this from the Singapore perspective, Brenda is talking about from the India, and maybe there are special guidelines that you offer your students for the Vietnamese competition.
Oh, okay. So when we look to that kind of structure, I always tell the students that I agree with Mark in a way that there is you might want to go on internet, but you might want to do that, or you might not want to do the same. So basically, the structures really is depending on the judgment of each of the students. There's no formats to follow. There is no form to comply. It is not a court litigation arbitration, which the process is very structured, and the law have been developed over the times to make sure that it has to follow certain things. So I mean, it's more like the choice of each of the person to present the information, and again, there is no specific structures that everyone has to follow.
Right.
That's my take on that one.
Thank you, Tuan. And just to let students know, of course, in the packet, you will see that there is this judging criteria. You will see that within the judging criteria of the 9 criterion, the points awarded would range from 0 to 3, 3 being excellent and 0 where a judge assesses that you have missed or have written poorly, any of the points that relates to the different criterion, right? On this same question, something that I think I need to put out there just for participants to also understand the judge's perspective, use of AI, right? I mean, there might be some students who think, well, the best brief must be, the best memo would be, I put the entire packet information into ChatGPT, use version 5.0, and then I get a wonderful brief that relates to everything that the panelists have been speaking so far. Would that not win the first prize? I invite comments from anyone.
Maybe I can jump in on that just because I've just written a paper on the abilities of AI in mediation particularly. So let me tell you what the research says so I can give you the normal academic opinion about plagiarism, and you'll have the same memo as everyone else. All of those things I think you already know. But let me lay out where the evidence currently shows AI capability to be. So there have been several studies in 2024 and 2025 trying to identify how effective AI is at mediation type activities. where AI is effective for law firms, both for mediation and other forms of legal activity, is summarizing long form documents. So all of the research so far does find that AI is as useful as a real lawyer and does it much faster than a real lawyer if it's just purely extracting information from 100 pages. It's just better at doing that. At all other forms of legal reasoning, AI is worse than the average human lawyer. It cannot engage in proper legal analysis. It consistently performs poorer than human lawyers when put up against them, even given the kind of extra time to do it and multiple times being put through the system. And so the current research simply does not support the use of AI for any form of legal reasoning that's even broadly complex. But it's important, I think, to understand why. It's important to understand why because AI work on a series of algorithms where you can put in a set of rules, and if the rules are very clear and if the information is structured in a way that matches the rules, then it can put out a good result, which is why it's good at summarizing documents. But at the type of legal reasoning that will be required both in a lawyer's real job, so arbitration, litigation, and here in your mediation memo, its judgment will be much less nuanced than your own judgment. Right? So you may think, well, I just defer to the AI, surely it knows better than me. The research does not support that position. Currently, what the research says is when it comes to any subjective decision making, AI performs poorly compared to any equivalent human lawyer. So just to let you know, that is the position that you will end up with a worse system, a worse mediation memo rather than a better one.
Thank you, Mark. And so maybe the takeaway for students is write your own, draft it yourself. But if you want to use it to check for typos or maybe to do some refinement in language, then use it, but use it in a considered and measured way, right? I think we've come to the time, 2 o'clock, and I think many in the midst would be looking forward to having a nice lunch after this. But let me just see if there are any other questions which I think might be pressing. There are two questions, Tuan, from Vietnamese students. You think that those two questions you want to address? First is from Bunok Lam Vai. It's asked about whether international instruments can be used as a legal foundation. And the second is in terms of legal documents, it's a bit similar question, whether we can mention in the memo the national one or the WTO. Tuan?
Oh, yeah. I think we always come back to the questions of law or legal documents. And look, I think Dorcas and other panelists have already talked briefly about it. Use the law, but be minded that balance. If you, as a student studying law, always there's a tendency to use the law and argue. And then we all know about that. And if the law can solve all the problems, then we never need mediation. And look again at the criteria. Law is only one criteria out of 9 criteria. If you focus on one criteria, you might miss the other important parts. So I cannot give a specific answer for each of the question, but generally focus on the criteria and balance out the legal, use the Vietnam laws or the relevant laws if you feel comfortable with that, but do not too much focus on that because you miss out the thing. And again, I might want to add a little bit on the AI thing. I always tell, same as Ted mentioned about, you might use AI, or Mark mentioned about the survey or research of AI products. AI is good, but it can also do harm. We all know about it. And again, it comes back to the final decision maker. Who is going to make the final decision? The judges might not use AI to judge it, right? We have a few minutes every day for this kind of thing. And we are human. So human is going to make the final decision. If we look at something written by the computer, we might not want to read it. So take consideration of the judges into consideration for the contest. Okay, the human make final decision. That's my keyword.
Thank you. And with that, and also because Nicole, your question I think has been superbly answered by Dorcas. Have a read and the chat answer. I think that we've come to the close of our webinar. And we've sort of done a long journey touching on the abstract principles and then moving into the nub of the competition criteria itself, and even touching on things that are in the periphery of the competition as well as in real life, what things to think about ethically as well as use of the AI. So on this important note, and I see other questions coming in, but maybe that can be raised directly with in this case, with Tuan. But for us, all of us here, 6 of us, we are very happy to be here. And on behalf of my senior fellows here, as well as the professors who are joining us today over their lunch break, we thank all the students for coming on. And on my part, I want to thank Dorcas, Alvin, Mark, Brinda, and Tuan for spending your lunchtime here and helping us to get the students up to speed in their competition submission. To the students here, please submit your competition submissions. We look forward to at least some of you here winning the top prizes. So thank you, everyone, and have a good day ahead.
Thank you.
Bye-bye.
Thank you, Dad. Thank you. Bye-bye.